As indicated on the slide, in assessing the reasonableness of a vaccination or testing policy, arbitrators have looked to some specific factors, and Kelly touched on a few of these earlier when he talked about the ESA and PWU decision, where the arbitrator wanted, there to be a demonstrated risk or a business need for the rules in place around vaccination or mandatory vaccination. So those seem to be factors that often arise in these cases that continue to come out.
In a private employment context, there is no common law duty of procedural fairness. This means that there is no duty to investigate and there is no duty to provide an employee an opportunity to respond to the allegations before terminating their employment. It is important to note in a wrongful dismissal case that the burden of proof, it's a reverse onus, so the burden of proof shifts to the employer. So that means that the employer has the legal onus to prove that the misconduct occurred and also establish that the misconduct warranted terminating the employee for cause. The reason why this issue arises is because at common law, there is no right to temporarily lay off an employee. Subject to the terms of an employment contract, the employer has an implied obligation to provide work, and the employee has the reciprocal obligation to attend work and fulfill their work responsibilities. So the issue that arose during the pandemic is whether the temporary layoff under the various statutes, regulations that provincial and territorial governments passed permitting temporary layoffs during the pandemic still amounted to a constructive dismissal.